Morning to all of you, Professor Bismibal Gopal Krishnan, Dr. Shaima, and other faculty members and participants. Uh, at the outset, let me confess that when Dr. Bismi asked me to speak on methods of legal citations, that caused an apprehension in my mind because this is one area probably no one is absolutely sure or perfect. And in the area of customized methods which are followed depending on the publishers, depending on the requirements of the universities and like things, I thought that this is an opportunity to, make forays into some of these areas because everybody talks about Blue Book, OSCOLA, APA, MLA, ILI, whatnot, or you can come out with your own method of legal citation. And in legal research, as all of you must have observed, we extensively depend on various sources. Whatever is written, whatever is the ultimate output of research, whatever may be the form, that is not 100% our intellectual property, our creation. It is culled out, it is, the analysis of various sources, whether paraphrased, whether quoted or summarized, along with our own, conclusions. Therefore, when we come across any scholarly work, any research work, it's quite common to find number of resources which are referred to by the scholars, authors, and many more. Now, in the good old days, probably, very few people used to really think about these methodologies as far as the citations are concerned. We were very happy to identify the author, then the publication, then the year of publication, the page number or publisher, fine. Same is the case with the books and articles with a little change here and there. But today it's not the case anymore because every institution, every organization, and every publisher, they have their own set of, citations which have to be followed by the contributors. Same, of course, UGC, to the best of my knowledge, has not come out with any particular mode of citation to be followed by the research scholars in respect of their research works. Subject to correction, but I don't think they say you follow Blue Book or OSCOLA or ILI or whatever it is. This is one aspect. There may be, regulations relating to the similarity index with regard to plagiarism and all, fine. But about the mode of citations, I think, the certain basic principles are to be followed as far as the regulatory agencies like, UGC or ICSSR, or sometimes the AICTE and many more are concerned. Now the question is, why should the present crop of researchers, including the good old and young, follow or learn about the various methods of legal citations is, there for everyone to understand. Because even a very small organization, even somebody who is coming out with an edited book or a compilation of certain research works, they insist on following a particular method. And in that method, probably, we can exhibit what kind of originality has been ensured, how the, in fact, the research or the search has been conducted, and from what kind of sources, in fact, the contributor has sourced the information. This is one important aspect. Before I go for this formal presentation, I must also tell you that today the references to the printed resources are coming down and references to the electronic resources are increasing. It may be because even the erstwhile printed resources are digitalized today. You can get access to the digital version of any of the treatises, majority of the treatises, if not all, treatises, commentaries, the good old journals, whatever it is, they are easily available either on the private websites or sometimes even in the public domain. Like if you ask that lady from Russian Federation behind the Sci-Hub or behind the LibGen, she will give us all kinds of access, no question about it. Like unmindful of the fact that she has been sued, she has been fined in United States of America and elsewhere, but she says fair use. Ultimately, many of the scholars can't pay for even downloading articles, $30, $50, $100. That may not be really desirable or practicable. Maybe, majority of the beneficiaries agree with her. Absolutely no doubt about it. But at the same time, nothing wrong in getting access, but there is everything wrong in not giving attribution. This is the real problem. So we have to attribute the sources. And when we attribute, again the citations come into picture. How do you attribute? That's the question. So whether you are following Harvard Blue Book 21st edition, which is also followed by the American lawyers today, or whether it is Oscola of Oxford University or something else. Of course, one can say, what's in a name? Like Shakespeare said long time back, what's in a citation? Probably there is everything in the citation, depending on the needs of the concerned organization, institution, or publisher, so on and so forth. So I made a very feeble attempt to put together some bits and pieces to understand and to share with you the various methods of the legal citations. And I have about 25 to 30 slides. Let me tell you that I don't claim any copyright in them. I'm very honest. I curled out all those points from different sources and I tried my level best to acknowledge the sources. Even towards the end also, you will come across the sources, which handbook, which site, which website, so on and so forth. So with this, let me make a very brief presentation, which may be followed by Q&A session if, So this is one important aspect, please. When we are talking about the first slide, we are on the first slide. As I already explained, everything doesn't come from the mind. And ultimately, we are talking about three components which dominate the content of any legal research or its output. Paraphrasing is one, quotations the other, and summary is the other. And ultimately, those three things, either of them or all of them, will be based mostly on the legal sources, which may be primary or secondary. This is one important point, either primary or secondary. Then, when we are talking about these resources, for example, primary legal sources, I need not mention. Probably the workshop is discussing about all these aspects in detail. We are talking about the case laws which are, created or coming from the courts, the various statutes coming from the legislatures, etc. Then when we talk about the secondary sources, I think here the real problem comes. Citing a case is not such difficult thing. Citing a statute also is not so difficult. The real problem comes when we cite the secondary sources, especially the books or the articles published in scholarly journals or some of the law reports like SEC journal section or AAR journal section, or which are made available on even blog spots, websites, and some of the policy statements. Here, I think one should be very careful in identifying those sources. Now, coming to the very rudimentary aspect of citation, probably we are looking for a care of address. When we are referring a particular material, we are making a reference to whether it is the decided cases or the books which are authoritative sources, or it could be anything else. That's what the dictionary meaning is. The citations refer to the references to decided cases, books of authority, and that is to prove a point in law. That's equally important, because there are some people even today, they think that almost every statement must have attribution. Every two lines must have attribution that may or may not be desirable in all the cases. As I already said, they are the path addresses or care of addresses of the books where we can source them or resource them. Maybe the articles, paper presentations, web pages, so on and so forth. This is another important point because the very purpose of referring to citations or giving citations is to enable the reader, whoever may be the reader. It may be, an enthusiastic scholar, or it may be a peer, it may be an examiner, or it may be a policy maker, in order to cross check whatever we state may not be 100% correct. There is every possibility of, in fact, the reader cross-checking the source, the correctness, the veracity, the authenticity, so on and so forth. Therefore, these citations must be given in the proper form. As I said in the beginning, normally in the good old days, we used to think about only these things. If it is a book, normally we used to start with the author's surname and initials, followed by the title, followed by the edition or volume, followed by the publisher, the year of publication, and the page. It's there on your screen. Harlow, Carroll, textbook on law of torts, law on torts, third edition, Sweet and Maxwell, 2002, 48 page. This is the most basic thing. I think, we need to mention because there is every possibility of multiple editions, more than one edition published in succeeding years, right? So therefore, the edition and year also matter. Let me give a small example. Whoever refers to jurisprudence today, they always talk about Solomon's jurisprudence. Fine, he is in fact, an original contributor. But when we look at the edition of that, some people refer to 6th edition, some people refer to 14th edition. 14th edition probably is revised by Fitzgerald. Then 6th edition probably, Granville Williams or someone else. And there are differences in these. So one must clearly identify which edition is being referred to. This is one. Similarly, when we are talking about journals, the articles published in journals, again, the author's name, then followed by the title of the article or paper. Normally, in the good old days, we used to always keep it in the quotes, double quotes. Like, in the given example, integrated ombudsmanry, joined up to a point. Then comes the citation of the journal. Here, the citation of the journal also is dictated by the journal itself. Many of the journals say, you cite us as under. ILI might say, or AIR might say, someone else might say. We have to follow that. So, which journal and, again, which edition, which page, so on and so forth. So, this is something, briefly about the citations. Then the next slide, please. When we are looking at the next slide, which is about the functions of legal citation, you can see that when you are referring to second slide, ma'am, Bismi ma'am, can we change the slide?
Yes.
Yeah.
Yes.
The second slide reads, yes, functions of legal citation.
Just a minute, sir.
We are on the second slide, sir. Functions of legal citation.
Okay, fine, good. If that is the case, then we'll go to the functions now. Coming to the functions of legal citation, you can find that in fact, three primary things are served by legal citations. They are there for you on the screen. One is that the legal citations identify the document or part of the document referred by the writer. That is one, identifying the source, you can say. The second one is the reader is given sufficient information where the source can be found, whether it is the document or the part of the document, whatever it is, and where it is available. That is equally important. For example, National Commission to Review the Working of the Constitution. It's Justice Verma Committee report. M.N. Venkatachalaya Committee report. Where is it available? I think there are multiple sources. You may get it from the Parliament website or Rajya Sabha website or Lok Sabha website, from where you can access it. So this purpose is served by the citation. So we are led to the, in fact, the source from which it can be downloaded or referred. And finally, the additional information. This is equally important. So whatever is the additional information regarding the material referred. So because the good scholar or good contributor will not rely upon only one reference. He will be referring to the related references also. Like, sometimes where the original source is not available, he may be referring to the reference to that original source in some other original source. Sourcing the source. This is the point. Therefore, this is the third important one. Because ultimately, to enable the reader to cross check, to enable the reader to cross check the reference which is given, and to satisfy himself that this is what is actually quoted, and to prevent even misrepresentation also. This is another important point. Anyway, these are the three things which you can see from a Cornell publication. That is the purpose of legal citation. I have given the source also. But as I already said, the ultimate objective of giving references or citations is to enable the readers to retrieve the cited reference, whether document or part of the document or whatever it is. Because if he wants to look at the original source, let him do so. We are giving only secondary source kind of thing. This is one important aspect. And because point is very simple. If we don't give the correct information or correct, in fact, address, what happens? Simply, take the case of sending our email to a wrong address. If it is, yahoo.com, in some cases, it is yahoo.co.in in some other cases. If one is given for the other erroneously, then certainly, there will be mailer demon. It will never reach the intended person. It is the same thing here. If the correct citation is not given, certainly, the readers will not be able to get access to that. And probably they will not rely upon whatever the researcher is trying to say. This is one important point. Researcher, writer, contributor, whoever it is. So wrong section cannot be given. See, some of the amateur writers or amateur, let us say, contributors, like the student beginners, they don't know the difference between an Indian law and, let us say, a law which is prevalent in England or some other country. So when they Google, they won't be able to distinguish between the Indian law and some other law. And sometimes they give the foreign law for Indian law. Then we will be, going in circles and circles. We don't find it. This is the case. Once I've seen this, in fact, some kind of reference was given in an MBA technology management syllabus to the Trademarks Act of United Kingdom. Whereas we had 1958 Act, now 1999 Act, this Act refers to something else. Then, most of the students were left scratching their heads. Like, in what way it is relevant? And we are not able to understand anything. Unless the syllabus is changed, I don't think correct questions can be given. This kind of situation might arise. Therefore, there will be a negative impact on the readers if there is a wrong citation. This is important. Same is the case with any postal address or email address, whatever it is, or an erroneous citation before a judge. Because you see, some people might cite, all of us are legal scholars. For example, Hussain-Ara Khatun, but there are 6 Hussain-Ara Khatuns. 1, 2, 3, 4, 5, 6 different judgments. Then K.M. Nanavati, there is not a single judgment. There are multiple judgments. You can refer to that. Bombay High Court, then again the Supreme Court, so on and so forth. So, if D.K. Basu, there are 1 or 2. Salem Advocates Association, 1 or 2. State of Karnataka versus Uma Devi, 1 or 2. So, which reference we are giving, that is very important. And the correct reference has to be given, whether it is a case law, that is only by way of proper citation. That is the point. We can go to the next slide, please. Citation principles. This is also equally important. So what are these citation principles? When you look at the citation principles, you will find that they can be kept in about 4 or 5 categories. One basic principle which is accepted by many is that there is a core identification principle or set of principles. So, the minimum elements which are necessary in order to identify any particular reference cited by the scholar, whether it's a document, portion of the document, whatever. And here the principle is only for the purpose of identifying the source and retrieving the information. So this is core identification principle. Then there are other kinds of citation principles. Take the case of minimum content principles. So here, for example, as I mentioned just now about the different editions, different versions, different cases between the same parties, right? So therefore, here additional information is required to be given. The basic purpose will not be only retrieval, but also to give additional information. This is important point. You can say, yes, in Uma Devi's case 1, this was the judgment. In Uma Devi's case 2, further it was consolidated, something like that. So I'm talking about the contract employees and all. Probably, labor law teachers and scholars, they know much better. So I'll give you a very live example, especially when you refer to some of the leading or landmark judgments which are in fact reported in maybe journals like Supreme Court cases, Manupatra, maybe some other standard journals and reports. You will find that in fact this particular judgment has been cited on number of occasions. It was distinguished in number of occasions, right? And just look at the editorial policy of each of them. Look at Keshavananda Bharati. Just if you access electronically the judgment of 1973, you can easily find out how many times it has been referred to by the Supreme Court, various high courts, right? All those things. So this is minimum content principle. The third one is compacting principle, because normally you see, if it is a Supreme Court cases, then it becomes SCC, that is a private reporter. Then, like in United States, you have United States Code. You need not, give the complete code every time. You can give the standard abbreviation, USC. So, compacting principle. The next one is about the formatting principle. This is important. Formatting, here everything, punctuation is important. Full stop, comma, typography. Then what is the order in which these citations are given? I'll give you some examples also, right? For example, in some of the jurisdictions, they also ask for ratio of the judgment. You say Mandal Commission judgment, Indra Sani versus Union of India. So you will mention AIR 1992 Supreme Court, page number so and so. Then in brackets you say 6-3, 6 per majority, 3 per minority. This, unless it is insisted by the organizers or by those who are calling for this kind of research work, we need not give. But if we have to give, we must give in a proper form. This is important. Then there is something called in-text citation. This is important. So what is this in-text citation? We are citing the sources which we are using in our words, sentences and paraphrases in actual body of your essay. That means, you are finding one source in the text, then again you are going to that other source. That is in-text citation. Therefore, suppose, in our text we are using some outside information. We should cite the sources of that information. That's equally important. I'll give a small example. Take the case of Spicy IP blog. All the IPR enthusiasts must be knowing. Or some other blogs. There, for example, somebody is mentioning about IPAB, abolition of IPAB. So somebody like Prashant Reddy and many more who will be contributing regularly, they write, we mentioned it here and here. You must have seen. What is that here and here? A link is provided there. If you click on that here, means some 2 years back, 3 years back, they mentioned about it, right? So this is one example of in-text citation. We'll go to the next, slide, please. Who sets the citation norms? This is important. And please try to understand that there is no hard and fast rule. Generally, there is no official citation standard. Sometimes some enterprising universities also they came out with their own, kind of citation. For example, Chanakya National Law School came out with this citation. Then in Maharashtra, a particular, standard mode of citation was developed, even though it was not officially approved. National Law School developed its own. But to the best of my knowledge, today majority of the law schools are following OSCOLA, right? And one can also follow Blue Book sometimes. As I already said, everything depends on the requirement. Whatever is the practice, whatever is the preference of the specific journal. If you are sending an article to Modern Law Review published from London, they insist on OSCOLA because the influence of Oxford University is very much evident. And if you are sending an article to something like Harvard Law Review or Pennsylvania Law Review or A Law Journal, they have their own book. These four law journals, in fact, they created a citation manual called the Blue Book. And then for many decades, this is the standard one. I think we are into the 21st edition today. And they say, honestly speaking, I have not completely read this Blue Book. Maybe some of you must have read, but you end up getting confused because our sources are a little different from their sources. Therefore, the basic things only you have to look at. And in fact, the courts are also insisting on following the Blue Book of Citation in respect of case laws by the lawyers. American Bar Association also sometimes relies upon the Blue Book as per the 21st edition of the Blue Book. This is one. And it is governing the citation practices of many law journals in the USA. So whatever are the editions which are published subsequently, then the citation education is being given a fillip. This is another important point. He is being given a fillip, and ultimately, the US lawyers are made to follow the Blue Book. This is one. And as I already said, the correct or the proper mode of citation depends on various factors. I've given a resource there, a write up by Peter W. Martin. He says that, in fact, it's a constantly evolving usage and it is reinforced in some cases, altered in others by the members of distinct communities. What the scholars do, what the students do, what the professors do, what the practitioners do. So it may depend on various aspects. Therefore, who sets the citation norms? It is normally the recipient, the person who invites the contributions. They decide ultimately what kind of citation is to be followed. This is as far as who sets the citation norms is concerned. Then, coming to the other aspect, when you are looking at OSCOLA, let's go to the next slide, please. Especially the OSCOLA thing. And I think OSCOLA is very dear and near as far as Indians are concerned. Most of the citations which are given by the scholars and teachers, they are as per the OSCOLA method of citation. And purpose of any citation is to enable the author to achieve consistency. And because I'll tell you one common mistake committed by many of the scholars and sometimes teachers also, like us. See, the moment you look at one mode of citation, one citation, let us say I gave you Indra Sani versus Union of India. Suppose this case is referred on 50 occasions in a particular paper or thesis, dissertation, whatever. Suppose on first paper AIR citation is given, on page number 6, SEC citation is given. On 25th page, it is a Manupatra citation. On some other page, some other citation. So it's clear that, some kind of plagiarism took place. That is, how can you give the same, case, but different, citations of cases, the different methods of citing the case. Therefore, if we follow the proper method of citation, there will be a clear, in fact, consistency throughout the work. So if it is mentioned in SEC, then the paragraphs may be different, the head note may be different, the long note may be different, the editorial opinion may be different. All those things we can rely upon. And that should be continued till the end of the research or the paper, whatever it is. Then coming back to this OSCOLA is nothing but Oxford University Standard for Citation of Legal Authorities. And many of the national law schools, I know even NALSAR also follows this. And it was devised initially by Peter Berks in 2000. Then it was in fact, the result of consultation with the faculty and law students of Oxford University. Then the publishers, OUP, which is a standard publisher today, Oxford University Press and Hart Publishing. You may recollect, Oxford University Press was in the forefront in challenging Rameshwari Photo Works production of course packs in 2016. You remember, Chancellor and Masters of Oxford University. That was one of the plaintiffs in the original suit. The same Oxford University Press follows OSCOLA, right? And initially it was, in fact, designed, created only for the exclusive use of Oxford University. But today, not only in UK, but overseas also, even in India, the very fact that majority of the, in fact, national law universities and others are following OSCOLA mode of citation, and also some of the legal journals, publishers, National Law School, for example. I think now there is a call for paper until 31st or so. It's by, I think, the school relating to the consumer protection, Center for Consumer Protection. Dr. Professor Ashok Patil is inviting some articles on the rights of the consumers in e-commerce, etc. Point is very simple. There you will find that he says only OSCOLA kind of citation shall be given. So this is what is happening in maybe in New Orleans, maybe in other places also, OSCOLA may be preferred. Then another point is that this OSCOLA is preferred because it is very simple. It is very simple because there is a minimum of punctuation. Unnecessary things, for example is EG only, not E dot, G dot, then something like that. IE, that is means not I dot, E dot, full stop, then dot, then comma, not that kind of thing. Okay, though it is based on the common practice in UK, but it is very simple. And another point is that OSCOLA is a footnote style. Everything is given in the footnotes, not in the endnotes. It doesn't encourage endnotes. Because, it makes the task of the reader easy, is it not? For example, one chapter or one paper may consist of maybe 250 references. So how will you go to the end, then refer to the endnotes? Best thing would be to go for footnotes instantaneously on the same page. We are in a better position to refer to that. And this task is achieved by OSCOLA kind of, citation, the footnote style. Next, please, electronic sources. I think I mentioned about this. When you are talking about electronic sources, I think majority of the sources are electronic. Is it not? Because again, even courts are encouraging citation of electronic sources. And no, in the good old days, I remember as a practicing advocate, as a junior advocate, whenever we used to go to the High Court for any kind of, especially final hearing matter, my senior, who used to ask our court clerk, the advocate clerk, and all the juniors to carry the books, especially in income tax area. So we used to carry 5 to 10 books easily, like the old volumes, ITR with markers displayed here and there. Today it's not necessary. Everything can be, cited before the honorable judge. Honorable judge is privy to that. We are also privy to that. An electronic source can be cited. It can be easily retrieved. Therefore, over-dependence on the electronic resources is one of the noticeable phenomena in modern times. And as I said, it may be online sources or it may be databases. Doesn't matter. Sometimes it may be databases. You are referring to, maybe law commission reports. All of them may or may not be accessed. Law Commission gives access, but sometimes there may be databases, right? And same is the case with others. Other reports, all of them may or may not be available, but the journal publishers are the same publishers are coming out with their electronic resources. So whether it is online resources, then the other one is disk, the other one is ebook publications, right? And point is the print alternatives are sometimes ignored. And as I already said, online resources or citing electronic resources has become the preferred mode for both primary and official distribution channels. Maybe it makes our life easier also, doesn't matter. Nowadays, virtual courts, virtual hearings, then if that is the case, electronic sources are the best way to rely upon. And as I already said, maybe for judicial opinions, maybe statutes, regulations, articles, government reports, for all of them, you can say electronic resources can be referred to. And normally, when we are citing an electronic source, we must make a specific reference to that electronic source, right? And normally, when that source is not available in the print form, in the good old days, that was the practice. Only when that was not available in the print form or widely available, then people used to go for electronic source. Okay, but today it's not the case. The things are changing. And how to cite? It depends. There are 2 or 3 models here. Look at the first example there. Steve Kenny and John Borking, The Value of Privacy Engineering. So this is Journal of Information Law and Technology, 2002-1. Then where it is available, it's clearly mentioned. But what you can see is that only the journals that, in fact, reference is given, but the date of access is not given. That shows that the journal is available at so and so place, Warwick University's, website or whatever it is. You can see that. Then the American kind of, citation of electronic sources, followed even by the American Bar Association. You will find, for example, there is a section on legal education and admissions to the bar, statistics, etc. Then you will go to that electronic, URL. That's what is, highlighted there. Look at that HTTPS, whatever, colon, / www, all those things. But in the brackets, you can see November 2020. Last visited November 20, 2020. This is one source, right? And same in the third example also you can see. James, Brimmelman, the structure of search engine law. Then 45, again you can look at this, New York Law School Legal Studies Research Paper number so and so, available at SSR, and this is important, Social Sciences Research Network. And till recently it used to contain, I think even today it contains multiple, in fact maybe millions of articles, papers in sciences and others, especially social sciences, right? Where it is found, this is the abstract, SSR and number so and so forth. So likewise, we can quote, the electronic sources. We can continue with the citation of the cases in the next slide, please. When you look at the citation of cases, especially, you will find that, cases also need to be cited based on the mode of citation preferred by the source. AIR may say, you may cite as AIR 1993, Supreme Court, page number so and so. AIR 1993, SC 1461, probably it is Keshavananda Bharati. Similarly here, when we are citing any other case, we have to give the name of the case, that is important, and the neutral citation, and the volume and first page of the relevant law report. Look at here, Phipps versus Boardman. If we are giving a footnote, 31 is in green color, again 31 is the footnote. This is from, appeals cases, 1967 in brackets, second volume, AC 46, in brackets the court, House of Lords. This is one. Or take the case of the other one, Boulting versus Association of Cinematograph, Television and Allied Technicians. Again, 32 is the footnote. If you go to the footnote, you will come across this, 1963 to Queen's Bench, QB 606 CA, Court of Appeals. So it depends on the kind of judgment and the court which delivers the judgment. And just you look at this. First you cite that you give the complete citation. But if you cite subsequently, then you can simply say bolting. You need not give again bolting versus association of cinematograph, blah blah blah. For example, you look at the third point there. Upjohn LJ said that the rule must be applied realistically to a state of affairs. There is a quotation. Must be to conflict. There 33. And where that is mentioned, that is note 32. Right? Note 32, page 638, bolting. You need not give the complete citation again. If it is following immediately after that, for example, after 32, the next is coming. 33 also is the same source. Just give IBIT. You need not give the bolting again. You have two choices. You can give just the name of the case, bolting, note 32, 638, or simply if everything is same, only page number is different, you can say IBIT 638, the same citation 638. Of course, I'll tell you about usage of IBIT, supra, infra, whatever it is in the subsequent slides. This is one, please. Then when we are citing the next slide, it is on citing the legislations. Citing the legislation. So when we are citing the legislation, normally, my teachers used to tell me that the must always be included. If you are saying something about the Protection of Human Rights Act, you must write the. But OSCOLA, simply it says Human Rights Act 1998. Section 2, yes, no full stop, small yes, 2. That's it, right? And if we are citing secondary sources, as I already mentioned, like a book, HLA Hart, the very famous book, Concept of Law, in brackets you can see second edition, Clarendon Press, 1994, 135. You will see minimum of punctuation there. And if you are citing subsequently, the same thing is cited, same source is cited on multiple occasions, then you need not give the complete citation in the subsequent citations. Right? For example, Austin, I mentioned just now, Austin versus Commissioner of Police for the Metropolis. That is example 1. And once you say, in fact, footnote 1, then you can see in the main text, only the names of the parties have come. Austin versus Commissioner of Police for Metropolis. But in the footnote, you will come across the complete citation. 2009 UKHL 5. Then 2009 AC 564. This is what our scholars must do. Please try to understand. If there are multiple resources, when I write annual survey of Indian law for Indian Law Institute every year, I've been doing it for the last 10 years. I refer to the case laws which are reported in SCC or Manu or sometimes even some electronic source, whatever. But if there are citations of those cases, I will give the equivalent citation side by side, just like this. You can see. And in fact, ILI says you put a colon, not semicolon, but colon. But here I put only 2009 in brackets UKHL 5. Again, you will also find same citation in 2009 brackets AC 564. This is important. Another point also, take for instance, if you are referring to a particular judge, we are citing a judgment and citing the opinion of a particular judge. Now it is quite common in modern times. For example, if you are talking about, let us say, Shreya Singhal versus Union of India case about Section 66A of the Information Technology Act, which was decided sometime in 2015. There we are citing, first we have cited that case, then we are citing the opinions of different judges. There you can see in the footnote, it should be like this, IBIP, 34, Lord Hope, then 39, Lord Scott. Here you can say Justice Chelameshwar so-and-so, Rohinton Nariman so-and-so, like that. So this is one way of citing. Then next please, OSCOLA citing thesis. For example, we have number of references to thesis also. and sometimes we refer to unpublished thesis. Therefore, we have to mention, the example is given there. Jawan Herberg, injunctive relief for wrongful termination of employment. We put it in single quotes as per Oscola citation. Then in brackets, what kind of thesis is it? It is a Doctor of Philosophy thesis, therefore DPhil thesis. Then submitted to whom? University of Oxford, and when? 1989. Let me tell you that unpublished thesis also is a very good source of legal material. In India, normally we don't do that. Like, Shodh Ganga and all. When you refer to Shodh Ganga, you come across all kinds of PhD theses, which are, in fact, submitted to different universities. That is one more important aspect, right? Then, similarly, websites and blogs. I think nowadays people are talking mostly about the electronic resources. This is one. And of course, Oscola doesn't mention very clearly about the proper method of websites and blogs. Example could be this: Sarah Cole, and that is the title of the paper: Virtual Friends Fires Employee, Friend Fires Employee. Then where is it mentioned? It is in a blog called Naked Law, 1st May 2009. Then what is the URL where you will find it? www.nakedlaw.com, so on and so forth. Then accessed. When did you access? It is on so and so date. Everyone knows. I think these electronic resources are simply cut, copy, and paste kind of thing. You will find it in the in the top box itself when you search. Only thing is you have to mention the date on which you accessed it. This is one. Next is about cross references, please. Cross references. When you are talking about cross references, this is very, very important, because while we are citing one particular source, it's quite common to refer to some other source also within the source, right? Then the question is how to cite that cross reference. This is important. And for example, just simply can't say see above or see, John Solomon jurisprudence edited by so and so. Where, which chapter, which book, which page. So you must identify which note. For example, a good cross reference. Look at the third point. A good cross reference takes the reader straight to the very place where it is cited. So you can easily identify where it is cited. Note 109, text to note 32, whatever it is. Then simply you can't give a broad cross reference, right, to a chapter. Chapter may run into 100 pages, 50 pages, 20 pages, and you can't expect the reader to read the entire chapter. So we have to give where, under which subheading it is mentioned, right? And as I already said, C, normally you say C note 109. That actually means what? Only that note is relevant. And you have seen that. You are inviting the reader also to see that. So that is note 109. Next, please. Latin gadgets. This is important. In fact, the best way of confusing the young scholars, of confusing even the readers, examiners, is to use these kind of things. Supra, infra, ante, ibid, opposite, locit, and contra. And in fact, most of them don't understand the meanings of this. Ibid is very common nowadays, right? Ibid, nothing wrong, because if one particular source is cited, immediately the next one also is the same, you will say ibid. Ibid means in the same place. Nothing wrong in it, right? And if the page number is different, you can say ibid, but page number is different. Okay, this is okay. Then CF. Normally, generally we compare. CF means compare or confer. So we say CF. Most of the research is all about comparing and contrasting. I think this point is known to all of us. Comparing and contrasting. In such a case, we use the word CF, right? And for example, the following paragraphs, FF. Following is FF, fast forward kind of thing. Example, simply you put EG. Paragraphs can be called only paras, that's all. Sections may be just one single S or double S. Was for singular section S, plural SS. That is will be IE. Again, as I already said, not I dot E dot comma dot comma. Volume will be only vol, VOL or volumes like this. This is, this is the beauty of the O-Scholar citation. It uses as little punctuation as possible. Let's go to the next slide, please. Then normally, when we are using the, in fact, abbreviations and initials in authors' names, we don't give any full stops, right? They are not normally, given any full stops there. Just the name, then followed by a comma. Okay. Then another point, appeal cases, as I already mentioned, in England it's quite popular, AC. And if it is Director of Public Prosecutions, DPP. In India, we hesitate to give UOI, Union of India, right? And we write complete citation, Union of India kind of thing. This is one. Then another point is commas must be inserted to separate the items. For example, here you will find, the two different journals which are publishing this case, Malcolm versus DPP. So one is EWHC, the other one is WLR. Citations are different, you can see. 2007 EWHC 363 admin, comma. That means this is the equivalent citation. And let me tell you, in India we don't follow this. Then same is the case with a journal. For example, Canadian Bar Review, it is cited there, 1953 edition. 31 Canadian Bar Review 47. So maybe 31 is the volume number or whatever it is. 47 is the page. 1953 is the year. So Fleming, that is the author. Remoteness and duty, blah, blah, blah. That is the title of the article. Then when was it published? 1953. Where was it published? In 31, maybe, Canadian Bar Review at page number 47. Simple logic. Let me give another example. Nowadays, everyone is talking about right to privacy. Lot of literature is coming out. And I think one article is very frequently referred by all those who are doing something in the area of right to privacy. That is Right to Privacy by Samuel Warren and Louis Brandeis, published in the Harvard Law Review in 1890. You can cross-check. The point is very simple. You can refer to that, like, how, Samuel Warren is written, how Louis Brandeis is written. Both of them are the authors there, joint authors. Then the title, then the journal. So you can compare and contrast. That is in USA. This is in India. Oscola. But that was much before Harvard Blue Book came. Please try to understand. Now, another point. How to italicize. For example, a word which is not understood by us or supposed to be not understood by the readers, because they may not be conversant with the word. It may be a foreign word. We must always italicize. You say ultra-virus. Ultra-virus is one. Per se is another one. Or it may be anything else. Right? Or menseria is something else. Those words and phrases must always be italicized, but quotations should not be italicized as far as Oscola is concerned. We are continuing with Oscola only, please. Quotations are kept either in single quotes or double quotes. If it is quotation within quotation, normally we go for double quote. Otherwise, it is a single quote. Right? This is one. Then, if there is a foreign word, we can't assume that the reader is a scholar. We can't assume that he knows everything. Therefore, as far as possible, we should give the simple meaning of that in the brackets immediately afterwards. And if you think that that looks very basic, then give it in the footnote. As simple as that. Right? This is one important aspect. Similarly, those words which become generic or which have become part of the common usage, they need not be italicized. I mentioned just now, ultra-virus has been used maybe 1,000 times or 1,00,000 times. Therefore, ultravirus has become generic. Star decisis is one, obiter dicta, ratio decidendi, a priori, fortiori, whatever it is. But there may be many more when we are looking at these concepts. But nothing wrong in italicizing them. At least, the reader will be in a better position to know or to probe further. Then, similarly, commonly used abbreviations are also not italicized. IE and example, that is an example. IE and EG, no italics are needed, please. You can simply write IE or EG. So this is another important aspect. If we go to the quotations, next slide, this is equally important. When we are talking about the quotations, as I already said, every research consists of any number of quotations. And some of the quotations are so meaningful that it will be difficult to replace them or paraphrase them. And to make that point forcefully, you need to depend on that quotation. So whether it is quotation from a particular treatise, textbook, or a case law, or a statute, right? But please try to understand that the rule is that they must be faithful to the original. Even if the quotation is wrong, factually, grammatically, language wise, you have to quote, maybe you have to put in brackets sick. You come across the newspapers quoting some of the celebrities and their tweets or Facebook messages or meta messages, whatever it is, and whenever they find something wrong they say sick, SIC. That means this is as quoted, which may not be correct, not my quotation but as quoted, kind of thing. Must be faithful to the original. Then where it is, except where it is necessary to change quotation marks from single to double or vice versa. Because you see, if you are quoting within quotation, then maybe double quotations. Then if it is single quotation, first hand quotation, it may be a single quote like this, right? Then suppose, sometimes the the comments on the quotations, we may be highlighting only one particular paragraph or one particular statement. For example, life of the law is not logic but experience and the felt necessities of the time, blah blah blah. You quote it to Justice Oliver Wendell Holmes Jr. He mentioned it somewhere, you italicize that, but immediately you must take care to mention that the emphasis is added by you, not by the author. That's important. And as far as possible, it should be in a footnote. And another point, how much can be quoted? Now we are talking about citations, no doubt. But what is the extent of a judgment which can be quoted? I know a gentleman, he said Supreme Court on right to education. And he must have added about 100 lines in that. But he reproduced verbatim the judgment of the Supreme Court in at least 3 cases. One is Mohini Jain versus State of Karnataka. The other one is JP Unnikrishnan versus State of Andhra Pradesh. And third one is something else, maybe TMA Pi Foundation versus State of Karnataka. They quoted the complete text, right? Right from first paragraph till the last paragraph. And before that, he made some comment within 100 words or 100 sentences. Fine. The question is this: are the judgments copyrightable? Is there any restriction on how much can be quoted? General rule is this. It varies from one institution to other institution, but the general rule is that up to 3 lines in the text, normally a single quotation must be given. Just now I mentioned there, you can see the Chief Justice explained that this power, which is in green color, is not limited to defense against aggression from a foreign nation. It is less than 3 lines, therefore you are putting it in single quotes. Then if it is another one, some author raised this question, again it's about 2.5 lines. Therefore again, single quotation. Then quotations within short quotations. Already you put a quotation, single quotation, but within that quotation we are quoting some more, then that short quotation must have normally, in fact, the double quotation. And another important point is punctuation follows the closing quotation mark, right? Punctuation, maybe full stop is kept there, or sometimes exclamation mark may be used, right? This is another important point. Next slide, please. Here you come across, if it is longer than 3 lines of quotations, we must indent the paragraph. This is important. Indenting the paragraph, I need not mention. For example, you have to reduce the size from left side and right side so that it is easily and strikingly clear that this is something different from the main text. Right? In such a case, quotation marks need not be used. If indenting of quotation is made, quotation marks generally not used. This is one important point. But suppose, a single quotation mark has to be used within the quotation. In such cases, indenting itself is almost like putting a single quotation. That is substitute for indenting or vice versa. Within that, you want to highlight something, then put a single quote. That's a point, right? Then, as I already said, leave a line space either side of the indented quotation. A line, above and below. If a line is quoted, left, then that will be very clear. Here you can see the examples. The House of Lords also concluded that the civil standard of proof, blah, 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 should be applied in such a way as to be sensitive to the seriousness of the matter. You see, seriousness of the matter, that starts with a quotation, which in effect means proof beyond reasonable doubt. So, that is the proof beyond doubt means the criminal, beyond the criminal standard. 27. But in the footnote, you can see that. That is the actual citation. The example 3 is the main part of the, in fact, the text, and 27 in green color in the third bullet is the footnote. Andrew Ashworth, social control and anti-social behavior, so and so. Then again, you are giving the correct citation of the journal. So 120 LQR 263. Then suppose that quoted something else, then you have to mention citing Singham and McCam, etc., etc. Quoting the quote, quotation continuing another quotation and the source. This is one example. Hope it's clear. Look at the other example. And here also in the main text, the author is trying to mention that Lord Hoffman reasoned as follows, blah, blah, blah. But here, where it is mentioned, look at the footnote number 12. That is, Transfield Shipping Inc. versus, Mercator Shipping, whatever. Like, emphasis is added. And where do you find all this information? You will find it in that particular source. You can see, I mentioned just now, the Oscola, Oxford University Standard for the Citation of Legal Authorities, 4th edition, etc. You can also get access to it. Explanation maybe is an improved one from my side, but most of the text is from this. Hope, I simplified it in order to be understood by one and all. Then let's come to India. Take the case of next slide, Indian Law Institute. I think this is the most common and frequent kind of, citation style followed in India, especially by the legal scholars. You know very well, I need not mention much about the Journal of Indian Law Institute, and they also publish the Annual Survey of Indian Law, and they also have a wide array of publications of, in the form of articles, edited books, textbooks, comments, so on and so forth. For example, the well-known citation index is given like this: MP Jain, Indian Constitutional Law, then 98, Common Law House, Calcutta, 5th edition, 1998. So that means what? Ultimately, that 98 is the year. Okay, or maybe 98 is the footnote. And then in the footnote, you come across Common Law House, Calcutta, 5th edition, 1998. Author comes first, followed by the title of the book, then comes in brackets the, in fact, the publisher, followed and the place of publication, the edition, and the year. MP Jain and SN Jain. This book is well known to all. Principles of Administrative Law. Then Wadhwa Publications, Nagpur, 2001. Then this is an American citation, Jerry L. Masha, and there are two other persons. You please look at this et al. Et al. Sometimes, there may be more than one editor or may more than two editors. It's not, especially in sciences, you come across sometimes even 50 editors or 50 contributors for a single paper. It is next to impossible to give all the names. Therefore, you can mention two. The remaining you can simply say et al. Means, etc. And here the source of the book, that is the American Public System Cases and Materials. Then that is a footnote. In the footnote you give this Westbrook, St. Paul, Min, 1992, like this. For edited books, this is also equally important because most of the publications are edited, right? So you have to mention ed dot in brackets, parenthesis. Susan A. Bandes, then edited, then the book, then again, the footnote, 180 is the footnote, then New York University Press, in the footnote you have to mention that at 180, New York, 1999. For example, on IPRs, you have this, these are all live books, you can find out. S.K. Verma and Raman Mittal, she was the director and he was one of the young, research, maybe, teachers. Both of them came out with a book, Intellectual Property Rights, A Global Vision. Then, from where to where, ILI Delhi 2004. Or Chhatrapati Singh, something on environmental law towards. But there you can see there are more than two editors. Or if there are only two editors, you simply write EDS. If it is et al., then there also you can write EDS. Then, how to cite? Next slide, please. ILI mode of citation for articles and essays. So this is simple. In fact, Indian scholars would be very happy to follow the ILI mode of citation for articles and essays. Upendra Bakshi on how not to judge the judges. So this is in Journal of Indian Law Institute way back in 1983. So notes towards evaluation of the judicial role. So there, the Journal of Indian Law Institute, 2/11/1983, 25th, whatever it is. Then P.K. Thakur, you can see another article. So 2 SCJ 26 to 38, 2002. So SCJ is Supreme Court judgments. Then Jutta Bruni, then it is something else. You can mention that. You can see the in which book. It is a book chapter probably. It is Ulrich, Berlin, Peter, so and so et al. Ensuring compliance with multilateral environmental agreements, blah blah blah. B.B. Pandey, who is regularly found in Delhi, ILI or maybe Indian Bar Council of India. So criminal law, then so and so volume of annual survey of Indian law, 171 to 198, published by so and so. In fact, every Journal of Indian Law Institute towards the end contains the proper mode of citation as per the ILI requirements. I need not mention, and these are some of the things which are mentioned. Hope it's clear. Then, when we look at case laws, for example, next slide, ILI mode of citation of, again, there you come across case laws. It's very easy. Keshavananda Bharati versus State of Kerala. See, there is a basic difference here. Oscola, it doesn't put a full stop there. If you are citing Oscola mode, then Keshavananda Bharati space V space State of Kerala. But if you are citing ILI mode, you will come across this. Keshavananda Bharati V dot State of Kerala. Then the footnote will be AIR 1973 SC 1461. You know very well, AIR is All India Reporter, 1973 is the year in which it is reported, SC is the court which decided, that's the page number 1461. Okay. And, for example, that to be written in the footnote, then just put a, comma, Keshavananda Bharati versus State of Kerala, comma, AIR 1973 SC 1461. And Indian Law Institute is very clear. For example, if you want to quote only a statute, we'll say we are using the here. Oscola doesn't use this. They simply say Information Technology Act 2000. We are saying the Information Technology Act, comma 2000. Then the year of the number of the act and year of enactment, Act 21 of 2000. If it is a particular section, you can see separated by a comma, small s dot, then the section 30. If it is the Constitution of India, again a dot will, a full stop will follow after the Constitution of India. But if it is an article, a provision like this, then comma, article AV is not capital. You must see A is small, ART dot 14 dot. Then if it is a report, you can see like Law Commission of India report, title of the report within inverted commas, then the page number, then the year of publication. So this is a very easy mode of citation, and unless the persons or the institutions are calling for a particular mode of citation, we need not, in fact, stick to them, and we can also follow ILI. Many of the research scholars today, they follow the ILI mode. Then another important point, when we have the Constituent Assembly debates, you can see. So normally, volume number must be given, then the debate, then page number. So volume number is 8, Constituent Assembly debates, then the page numbers 31 and 32. If they are electronically available somewhere, you have to mention that. Like, in the next one we have seen. So CAD, Constituent Assembly debates on April 29, 1947, available at URL address, last visited on May 30, 2008. Then if it is a parliamentary debates, then where they are available. Again, there is some kind of cross reference there. Electronic source has to be given. URL is very important. And if you identify the URL and the date on which you visited, you have to mention the date, because there is a possibility of the manager of the website removing that page or removing that source. Then people might say, no, I referred today, I didn't find anything. You can say, sir, it was available on so and so date for that particular purpose. And if it is audio visual sources or documentaries, etc., then again you have to mention that. Then title must always be in italics. This is important, and followed by the year and where it is available. This is another one. Then same is the case with speeches. That is also equally important. For example, let us say, I think within the next few days, there will be a chief justices of the state high courts and the chief ministers with the Supreme Court judges. And there somebody gives a speech. You have to quote that. So how to quote that? Then title of the paper, the name of the conference, then where it is held, and where it is available. URL must be mentioned. Last visited on so and so date is absolutely necessary. This is one. Continuing with the ILI referencing, then how these Latin expressions are used in the next slide, please. Supra. Supra is normally, this is important. IB is with regard to the immediate next reference, but supra is not like that. So when we are giving successive footnote numbers to the footnotes, you can, supra means above. Simply you can't say supra just like that. Supra, one particular source may appear at footnote number 1, then again on 5th page at footnote number 34. So you have to mention supra note 5, or you can say supra so and so, footnote number 1. Then so supra note 1, then at so and so. That is one method. This is equally important, right? And it may be equally applied in the context of any kind of electronic source or any other source for that matter, section, article, etc. This is one. Because if it is immediately after one after the other, you go for IBIT. If it is more than that, maybe there are certain spaces between the last same reference and the present reference, same reference. Then we have to mention supra. This is important. And here, as far as ILI is concerned, I with dot. This is important. I with must be followed by dot or ID followed by dot. Okay. And example also you can see. If it is simply EG as per OSCOLA, here it is E dot G dot. This is important. Right? Example ID Article 14. You can see that. It's very simple. These are the commonly used citation styles, please. You can find out normally, but any footnote with a, in fact, period, that is full stop, that must end with a full stop. You can't leave it open ended like that. Footnotes must always be, closed with a full stop. This is important. As I already mentioned, today there are any number of, in fact, citation styles which are followed. OSCOLA we discussed extensively. One example can be seen there. VK Ahuja, Law Relating to IPR, blah, blah. Second edition, LexisNexis 2013-83. If the same thing is cited, for example, take the case of my respected guru, Professor V. Nageshwar Rao. In the blue book, it is mentioned like this. V. Nageshwar Rao, the Indian Evidence Act, 323, second edition, 2015. I think it's Butterworth's LexisNexis. If it is, in fact, Indian Law Institute, I already mentioned about MP Jain, Indian Constitutional Law 98. Basic differences you can see, right? And where to put the full stop, comma, addition, all those things. Now I am coming to, I think so far we have seen why. Then the next question is how? Which citations style should you use? I already mentioned. It depends on the department of the university, depends on the submission guidelines of the target journal. Only thing is we need to spend a few, minutes of our constructive time and usage in order to acclimatize ourselves with the citation styles. That's important. For example, as I already mentioned, European Journal of Criminology, they say we follow the Harvard citation style. And the Journal of Management and Journal of Marketing, they use something like APA style, right? That is American Psychological Association style. And till recently, we used to use MLA handbook style. And even for legal resources, not only for literary and artistic kind of citations, right? And some journals, they have their own style. This is one. And if you are using any program such as EndNote, Mendeley or Zotero, our task is much easier. They can easily convert them into the required, the mode of citation, right? So we have to target journals, select the target journal citation, then again we can correct the style as per that. And then nowadays information technology helps us a lot. MLA handbook, as I already said, sometimes normally, author and page number will be, mentioned in MLA handbook and many more. APA style, I mentioned about American Psychological Association. And this was something like, which was actually used in psychology and other social sciences. Today, I think even in law, they are using it. OSCOLA, I explained extensively. So OSCOLA is used, in law schools now. And this is the predominant mode of citation in the law schools throughout the world. Then comes Blue Book. Blue Book is not so difficult. Only thing is you have to go by the book. As simple as that. So this is a authentic mode of American legal citations. Then whoever is writing a legal in the US. But let us remember the fact that Indian need not publish only in India. He can publish anywhere else, right? If you are talking about Sri Vidya Raghavan, who is an expert in intellectual property rights, a product of National Law School of India University. Now she is a professor in Texas A&M University, right? And there she publishes number of articles in various journals. Therefore, she may be an Indian, she may be a US citizen, doesn't matter. World has become a global village. Therefore, as per the requirement, we have to follow the, in fact, the citation style. This is important. So Blue Book also is very, very popular. And if you are willing to get your works published in USA, especially in any of the standard law journals and other similar publications in USA, I think we need to follow the Blue Book. So these are the further readings, please. I mentioned in the beginning that I have taken them from various sources. So one is ILI mode of citation, there the URL I have given from where you can download it. And about Blue Book, you have the Harvard Education Library, I gave it. OSCOLA I gave. Then there is another one, MLA Handbook Style I have given. And another very, very interesting source, useful source, because as far as the mode of citation etc. Are concerned. ILI is the book on legal research methodology. It's a collection of articles edited by Professor S.K. Verma and Afzal Wani, has been a very good source of, in fact, guidance to many of us. But on citations, not much light was thrown. Some attempt was made by other experts, but I believe that as on today it is Professor Ishwar Bhatt's wonderful book, Idea and Methods of Legal Research, which is published by the Oxford University Press in 2019, which throws lot of light on the various sources of citation. Of course, sir tried to make some kind of comparative study there, right? But as I already said, in the absence of any, in fact, fixed mode of citation, then it depends on various factors. But only thing is this: we have to spend at least maybe 5 to 10% of the time, the total time spent for the research on citations, which is equally important, so that the flow of our research and the output report writing will be consistent, continuous, and without any hiccups. So these are some of the stray thoughts, which I wanted to share with you. I wish all of you a very happy legal research. If there are any Q&As, then I'll be too happy to answer. Over to you, Professor Bismi.